Good morning, political scientists. I am back on track, sort of. I am recording this sufficiently in advance. Yesterday we looked at the role and functions of the Supreme Court, and we looked at the kind of jobs they do and the sort of purpose they serve in our system, and the purpose they serve, I say in our system, in the UK political system. It's not necessarily our system, it's just the system under which we live. Today I'm going to look at, well, the relations between the branches. That is, after all, the overall title of this unit. So, having now introduced the judiciary, welcome to the judiciary, this is judiciary, and these are my students. They're lovely, aren't they? They're credits to the school and credits to themselves. What we're now going to do is look at the relationship between the different branches of government. In particular, we're going to look at the relationship between the executive and parliament and the judiciary, specifically the Supreme Court. How do these decisions tend to go down? How do they tend to work? And what is meant by checks and balances anyway? Do we even have them in the same way that the US system does? Now, I'll be honest, you'll have noticed in the textbook doesn't refer to checks and balances. I am doing this very deliberately because when we come to do the US system, there's an awful lot on checks and balances. And because the whole idea of that is it's a synoptic unit, i.e. you make comparisons between what we've done with the UK political system and the US political system, it makes sense, for me at least, to try and flag up where those things may occur. So we've talked about the executive, we've talked about the legislature, we've talked about the judiciary. Well, checks and balances are the relationships between them. So that's why I started with the question mark. Do we even have them? And today's lesson, is where we're going to look in a little bit more depth at that. So let's talk about the Supreme Court versus the executive and Parliament. I'm very pleased with myself on the background image there. That's Lady Hale, the President of the Supreme Court, who made two rather landmark decisions, one of which was with the spider brooch, and the internet went absolutely nuts for the spider brooch. I don't understand. And of course, our current Prime Minister, Boris Johnson. So let's start in a strange place, I suppose, talking about codified constitutions. If you'll remember, a codified constitution is a constitution that is written down and easily accessible, and that provides a higher authority than any legislature or any executive body within a state. So in the United States, for example, the Constitution is sacrosanct. The Constitution is the authority to which all other authorities bow. And that means that their Supreme Courts are able to strike down acts of government and anything government does in the name of the Constitution. Their job is to uphold the constitutional values. And that goes for any country with a codified constitution. The only one that really counts here, I suppose, is the US one, because we're doing A-level and we're not doing university level just yet. So in that sense, SCOTUS, the Supreme Court of the United States, is far more powerful than the UK Supreme Court. And you can see why I'm not shortening that to SCUC, because it just sounds awful. UXC. I'll call it the UK Supreme Court rather than... SCOTUS is just a nice way of referring to the Supreme Court of the United States. First of all, the UK Supreme Court has no higher authority to which to appeal, and as a consequence, it cannot strike down acts of government, nor can it suggest that that's what its function is. Its function is not to uphold any kind of constitutional value. So what is it doing? Secondly, it does have some functions of power. That is, it has jobs that it does that give it powers almost by default, which are the two greatest words in the English language. In case you're asking me, it's de and fault. First of all, they can set precedents. That is, they decide the meanings of the law. They decide what a law actually means in practice. Now, I've talked about this already. I talked about it yesterday. But what I didn't do was go into depth about how that relates to their work with Parliament. So I'll give you a couple of examples to prove a point today. The second thing that I hinted at yesterday was ultra vires. That is, they can decide when a public body is acting beyond its authority, and to make sure they act within their authority. Authority, remember, is the legitimate power that they can dispense, that is recognised and consented to by all. So when a public body, that could be local government or it could be government itself, given we're talking about between branches here, I am going to talk primarily about government bodies, but it could be any public body. When they make decisions, are they acting within the bounds of their authority? And that can be quite an important thing. Sorry for keep fiddling with my hair, by the way. It's just at that irritating length. It's gone past the bit where it gets in my ears and causes wax, and is now at that point where it keeps falling in my face. I'm sure I'll find a way round it eventually. Haircut. Yeah, I know. Thirdly, they decide where sovereignty resides. Given that we've got an uncodified constitution and a plethora, I love that word, a plethora of different bodies that run things like devolved bodies, for example, and various local governments and overlapping areas of authority, it is important, some might say vital, to work out where sovereignty actually lies in our system. Now, I will return to this. I'll talk about it here, and then I'll leave it alone for a bit, and then I'll come back to it with a fiery vengeance at the end of this part of the unit. So don't worry, that may well be in classroom. We'll see how we go. Basically, where does sovereignty lie for different bits of the UK system within that UK system? Those overlapping circles that caused me such pain yesterday, because I messed up the animation, mean that it's often difficult to tell, and therefore we need a body to, well, adjudge where that goes. I'm sorry my eyes keep flicking away from the camera, by the way. I have noticed this on multiple playbacks. It's because I'm checking the screen, which is just below the camera. The final job they do is they can decide whether or not the British government has acted within the limits of the Human Rights Act. The exact wording of the Human Rights Act says that the Supreme Court, or indeed the courts, can decide whether or not existing Acts of Parliament or new Acts of Parliament are within the bounds of the Human Rights Act passed. Now, they don't have the power, as I've previously stated, to strike down Acts of Parliament, but they can adjudge whether they fit the Human Rights Act and then issue a proclamation. We'll come on to that in a moment. More a statement, I suppose, than a proclamation. They're not a legal authority, though they are authority on legal matters. Let's talk about precedent, determining the meaning of a law. The Supreme Court carries more weight than most other courts when it comes to this. All courts, all judges have the power to determine the meaning of the law. When a law is untested, when there are no precedents set, when no judgment has been made on a new law, the first judge that comes into contact with that law and has to prosecute that law and make it work and stick, therefore gets to set a precedent. Now, more often than not, the precedents are irrelevant. They are quoted by lawyers, they are known by solicitors. I worked briefly for work experience in GCSE in a lawyer's office, solicitor's office, and precedent was a big deal. He had me read through a law library to read up on precedents. I honestly never wanted to be a lawyer. No one really knew what to advise me to do as a work experience in GCSE, and so I ended up by default going to a lawyer who shut several months after I went there. It was an interesting experience. Anywho, the point is you set a precedent. A lot of these precedents are boring. They basically say, this law, as it stands and as it's stated, is carried out. Bang! Done. Occasionally, a precedent is set that changes the meaning of a law, subtly, and in most cases boringly. Trust me, they're not huge differences, and that creates common law, something I've already mentioned. However, when the Supreme Court sets as precedent, that carries a little bit more weight because of the sorts of cases that they decide upon. So, more than other courts, the power is joint enterprise, and it worked like this. If you've got a crowd inciting a murder, kill him, death, and then someone in that crowd takes up, I don't know, a weapon and murders someone, then everybody in the crowd can be equally taken to court and prosecuted for murder. They all effectively took part. That's called joint enterprise. Now, it also works for other crimes as well. If you've got people egging other people on, then they are jointly responsible for the crime that follows. So if you incite someone to shoplift, you are as guilty of shoplifting as the person who did the shoplifting. So be careful with your peer pressure, is my point. Or, but I didn't do it, I got someone else to do it, actually isn't a defence under joint enterprise. However, in the case of murder specifically, according to the case of R versus Jogi in 2016, the Supreme Court overturned the concept of joint enterprise, arguing that hinges on the proving of intent. Did people mean to do things? And murder is one of those cases. You've got to prove that people intended to kill. It's why when you've got planned murders, obviously that's an intent to kill. Whether or not the actual act itself is linked to that plan, you had the intent to kill. Whereas manslaughter is without the intent to kill. It was done almost by accident. So whether or not you benefit from a death is irrelevant. Did you intend to carry the death out? Did you intend to carry out murder? This meant that each individual member of an inciting group would have to be proven to have the intent to kill themselves, or through their incitement to cause someone else to kill. And that would be the burden of proof. It is not enough to simply egg someone on to kill. You have to have the intent that it would be carried out. I'm trying to think of something that this would be. Generally speaking, with stuff like this in politics, it tends to come down to sexual behaviours. In, I don't know, mutually consensual rough sex, and you yell, kill 'em, is that really incitement to murder? If someone dies as a result of that, would that not automatically become manslaughter? After all, one is in the throes of passion. You can see why this distasteful example is relevant here to talk about the intent to kill. So basically, I'd have to be tested for all group members. It's not enough that they're all just there. Furthermore, you've got the extent or of effect of human rights on individuals' relationship with the states. Now, you might say, so surely that comes under the Human Rights Act. And I say, well, yeah, kinda, but this rests on a precedent. Allow me to explain. In 2014, there was a case of P versus Cheshire West and Cheshire Council. P was a man with cerebral palsy and Down syndrome, who, over time, his condition was deteriorating. The local councils argued that they could give him a better quality of life if they deprived him of certain freedoms, i.e., forcing him to live in a particular institution, being constantly monitored by the state, and being unable to take the decision himself to either leave or move out should the opportunity present itself. So if there were better facilities or better digs being available and this P wanted to leave, he would not be able to. And the council argued that this was important because it removed his liberties, certainly, but it improved his quality of life by so doing. They could look after him, prevent him from having accidents, and prevent him from going to lower quality care homes, for example, because they could provide the highest quality care. Now, this limits his freedom to make his own decision. The Supreme Court came down on the idea that actually a gilded cage is still a cage, in the words of their president, Lady Hale. Gilded means gold-plated. So she argued, sure, the situation that the council is putting this person into is better than the alternative. And sure, they're going to look after him and they have his best interests at heart. And absolutely, he's going to have a higher quality of life. However, if he decided differently and wanted to do his own thing, he would be unable to do so. Oh no, that's not it. And therefore, it infringed on Article 5 of the European Convention on Human Rights, the right to personal liberty. He should be free to take the decision to leave those accommodations provided for him should any other opportunities become available, and the council would not be able to prevent him from doing so. That was a very loud noise. That puts it in time period, doesn't it? It's about 3:30. So there's that. The next thing when it comes to determining the meaning of the law is a Supreme Court decision from 2010. In the case of R versus Chait and others, 3 MPs claimed that parliamentary privilege meant that they could not be charged in a court of law over the charge of false accounting on their expenses. They'd provided false expenses in order to defraud money from the public purse, and they argued that, sure, they were guilty of that, sure, they'd carried that out, and sure, they'd lied, but they could not be prosecuted or be sent to jail because those crimes took place on parliamentary property. And as a consequence, due to parliamentary privilege, if you remember, this protects them from libel, they were safe to do that. They could do that as much as they wished, wherever they wished, with whom they wished, how often they wished. They could not be sent to jail. The Supreme Court disagreed, and they argued that common law had already set a precedent. Remember, common law is set on precedents. And they cited the case of Bellingham. Bellingham had killed the then Prime Minister in 1812 on parliamentary property. He had been arrested, he had been convicted, and he had been sentenced to execution and then executed. In other words, that a crime was committed on parliamentary soil meant nothing. The law of England applied to all English soil, and Wales, and Northern Ireland, not Scotland. Scotland has a different law, and therefore it does not matter if you break the law in Parliament, or down the Thames, or on a boat just off the coast. You are still prosecutable under English law. And as a consequence, these 3 MPs were found that they could not use that as a defence. They were convicted of false expenses, and were they sentenced to jail? I can't remember. Sentenced to prison? They received prison sentences for false accounting on that basis because the Supreme Court, as they pointed out, was like, yeah, no, seriously, I can't believe that I have to say this, but yeah, you break a law in England, you will be prosecuted for that law, though parliamentary privilege still protects you from potentially libelous statements, i.e. you can say things in Parliament and impugn others in Parliament in a way that you can't do elsewhere in life because they need that freedom in order to make laws. I don't think you need the freedom necessarily to carry out fraud or murder, which was the point. The next power is all about determining whether a public body has acted beyond their authority, ultra vires in Latin. Ultra vires, I suppose. It's established through a procedure known as judicial review. Someone has to come and ask for a judicial review. They say, this law of a public body or this act of a public body, we think goes beyond their authority to do this. So it's not something that the Supreme Court or any other court can just do. Now, the Supreme Court, when it comes to judicial review, tends to make decisions on government decisions. Of course it does. And government acts, or things carried out in the name of government by government ministers. So, for the purposes of this discussion, I'm going to focus mainly on government decisions. The definition of ultra vires is acting beyond one's authority, which I suppose is more important back in the day than it is these days, but you can sort of see the medieval aspect of that right there. Thus, any actions found as being undertaken ultra vires can be quashed, i.e. they can be removed from the record, they can stop being a thing, because they were not legal when they were originally carried out. So any reaction to or consequence of the actions of the decisions made that were illegal no longer count because they weren't carried out in a legal manner, because the decision they're based on is not legal. You can just remove it. It's like it never happened. And therefore all the things that were undertaken under that suddenly become challengeable under law because, well, those decisions were carried out based on an illegal precedent. Does that make sense? I've maybe complicated it more than it needs to be. Perhaps the examples will help. So hold your questions. Let's go through the examples, see if that clarifies matters. The first example I'm going to talk about is the 2016 Supreme Court adjudging Chris Grayling, who had been the Justice Secretary, or Secretary of State for Justice, however you want to phrase that, as acting beyond his powers, ultra vires. Basically, what Grayling had done was he changed laws and ideas for legal aid and said that if you'd been abroad consecutively for 12 months or more, then you were no longer entitled to legal aid in the UK. Now, that didn't matter when those 12 months had taken place. And you can see how this could be used specifically against those with dual nationality or against those claiming asylum rights through immigration. I'm sorry about that noise. I dread to think what it must be like through this microphone. I imagine there'll be at least one more, and I apologise. So you can see how this would be applied and why it might have been raised as judicial review. Now, he'd done that in 2014. And the Supreme Court basically said it wasn't legal because it had been carried out without a debate in Parliament. Had it been debated in Parliament and been passed as a new law, then it would have been fine. But because he'd done it on secondary legislation, i.e. taking an existing law and amending it, it was not actually within his authority to do so, because it fundamentally altered the way the law was supposed to work in a way that the framers of the original law had not foreseen, nor had they provided for in that original law, as evidenced by the fact that he had to change the Act of Parliament. Thus, it wasn't secondary legislation adapting an existing law in a way that everyone understood. Rather, it was new legislation, primary legislation, and should have been debated in the House of Commons in Parliament before it could be passed. So it wasn't the idea of the law that was wrong, nor even how it was being used. It was the fact that the process had not been followed correctly. My next example is not in the textbook because it didn't exist yet, and that was the prorogation of Parliament in September 2019. Now, you might recall a bit of furore back then, if you can think back that far. It was pre-coronavirus times, and therefore hundreds of years ago, because, the time between the dinosaurs and now is 65 million years, and the time between now and the end of lockdown, which is tentatively put at the 24th of June, is ages. So, it's difficult to remember. Basically, the High Court had previously ruled on this already, and they'd said it wasn't a case that could be seen by the Supreme Court anyway. It wasn't for the judiciary to decide whether or not the prorogation of Parliament, i.e. closing of Parliament for a short time, was a matter for a legal requirement. It's not for the courts to decide that. That is a government decision based on the executive and Parliament. They take the decisions, not the judiciary. It was not justiciable. That word there with an extra I where it doesn't belong. Justiciable. Justiciable. I'm going to struggle with that word like judiciary. Sorry. Basically, the High Court ruled that it was not not a matter for the courts, and at the same time, the Court of Session in Scotland said, actually, it kind of is under Scottish law, because there is a Scottish law precedent for that, where nobles had taken a king, King Duncan, I believe, but don't quote me on that one, might have been a King Malcolm, to task, saying that he was acting beyond his powers in not holding parliaments. So you've got a clash here. And that meant that the Supreme Court had to intervene. And the Supreme Court got it referred to it on the 11th of September 2019. And from the 24th of September, they handed down a unanimous verdict. They all agreed that this was a prerogative power, i.e. it came from the monarch to the Prime Minister to prorogue Parliament. They did not say whether or not the monarch should follow the advice of the Prime Minister. That was beyond their ability to say. What they did say was that because it was a prerogative power, i.e. devolved from the monarch to the Prime Minister, it therefore meant that they could judge on it. How did they come to this decision? Well, they cited two previous precedents. Entick versus Carrington, which we already know about bailiffs having to have a warrant to go onto private property, and therefore the government could be checked upon. Entick versus Carrington set the precedent that courts could check government decisions after they had been taken and see whether or not they fit the constitutional arrangement. In that case, it was bailiffs going onto private property, and the courts found that they couldn't do that without asking the courts for permission first to make sure that the government wasn't overstepping its bounds. That was freedom from the government, and they argued that this was an element of that, in that there were many MPs that did not want Parliament to shut, and that they represented the will of the people who also did not want Parliament to shut. And Parliament didn't get to make a decision on its own prorogation. The second thing they cited was the case of proclamations in 1611 that essentially gave them the power to check what the government was saying against law. And they argued that these two precedents meant that there was supervisory jurisdiction over the executive, i.e. the Supreme Court could check what the executive was doing. They couldn't check Parliament's work, but they were allowed to check the executive's work, because Parliament, in this instance, was unable to do so. Thus, they argued, in this way, it's Latin for in this way, I just love the word thus because I like Latin, you might have noticed. Thus, it was justiciable. Justiciable. Yeah, that works. Justiciable. They could make a decision based in law upon it. Following that, they found it relatively easy to say that the prorogation of Parliament was unlawful. This is the text of their decision. I looked it up, the link down there, it's on the PowerPoint, you can click it yourselves, will take you to the actual decision. And bear in mind, this is not in the textbook, so it's an extra example of this point. It is impossible for us to conclude on the evidence which has been put before us that there was any reason, let alone a good reason, to advise Her Majesty to prorogue Parliament for 5 weeks from 9th or 12th of September until the 14th of October. We cannot speculate in the absence of further evidence upon what such reasons might have been. It follows that the decision was unlawful. And as a consequence, on the following day, the 25th of September 2019, Parliament returned to session, and the government could do nothing about it. They had been found to act unlawfully, and the Supreme Court had pointed out that they had the power of supervisory jurisdiction over the executive to see whether the decisions they had made would be ultra vires. Now that is phenomenally powerful. The Factortame case, which I will come back to later, that's in 1988, had proved that they did have supervisory power over Parliament. This was over the executive. Now, I said before, and you might remember me, so you just said they didn't have supervisory powers over Parliament. No, they didn't, not on this basis. Entick versus Carrington didn't give them that, and nor did, sorry, my hair's really a mess, and nor did the case of proclamations. That's something called the Factortame case. So, yeah, I was misleading, but I was trying to make a point. Hopefully the comparison stands. How am I doing for time? We're all right. So, the penultimate thing is the location of sovereignty, which is about as far as I'll get in this lesson. That is, where does sovereignty lie in the UK system? And I've said before, it's difficult to ascertain. I showed you that diagram, I overlaid coloured circles on top and pointed out that it's really difficult to work out exactly where it is. We can talk about the Queen in Parliament, but the Queen in Parliament doesn't actually exist. It's a concept, it's an idea. Disputes, therefore, about where sovereignty lies, who gets to make the decisions, who has the power to make decisions, increase the importance of the Supreme Court in the UK system. Such arguments don't exist in the US system, for example, as there are clearly delineated areas of influence and areas of power in the US system. I mean, sure, they sometimes try to overlap, but generally speaking, there is some form of separation of powers. So different areas of US government have different responsibilities and different sovereignties. That is not the case in the UK, where there is no real distinction between them, and therefore it falls to the Supreme Court to make those decisions. Let's use an example to prove the point. Now, this is in the textbook because it had taken place in 2017. It is the case of R. Miller versus the Secretary of State for exiting the EU in 2017. The government claimed, immediately following the decision of the referendum on the 23rd of June 2016, the government claimed royal prerogative. That is, they had the ability to negotiate treaties and to negotiate the exit of those treaties without recourse to Parliament. They could do as they wished. Parliament had no say. Parliament had no right to interfere with what the government was doing. As royal prerogative, i.e. the power of the monarch passing to the executive could do as they wished. The executive in this case being the government and the Prime Minister. Now, you'll remember from your work on May, when you were trying to write those essays about how presidential May was, this is an element of style. May was attempting to act as a presidential Prime Minister in pushing forward her idea for what was to be achieved and not letting Parliament have a say in it. It's really difficult with the microphone right here to move my hands around. I'm doing my best. And on the 24th of January 2017, that case was finally adjudicated on. It was brought by Miller in 2017 in an effort to challenge the government's decision. And the Supreme Court struggled. There was an 3 majority decision against the government, saying that it was not their royal prerogative. That means that 3 justices did believe it was the royal prerogative of the government, and the government were right to say that. But 8 judges argued that it was not a case of royal prerogative. They argued that, it works like this. Back in 1972, not 1974, as I said in a previous video, my apologies. Back in 1972, when the UK Parliament ratified the Treaty of Rome and thus joined the European Economic Community, that had been an act of Parliament. It had been debated in Parliament, it had been voted on in Parliament, it had been an act of Parliament. Parliament made the decision. Parliament is sovereign. Therefore, the rights conferred by that decision to be adjudicated over by the European Court of Justice, for example, and to have freedom of movement within the European Union as it had developed over time, those rights had been granted by Parliament. Rights that Parliament grant can only be taken away, argued the Supreme Court, by Parliament, because Parliament is sovereign. Therefore, the executive, the government, did not have the power to force anything through. Parliament would have to debate it. Theresa May's majority wasn't quite large enough to make that happen. So, Parliament had sovereignty, not the executive in this instance. Basically, the Supreme Court had supported Parliament. This was their reasoning for their decision. Withdrawal effects a fundamental change by cutting off the source of EU law, as well as changing legal rights. The UK's constitutional arrangements require such changes to be clearly authorised by Parliament, not by an election, not by a government, but by Parliament. At this impasse, basically the Daily Hill called the judges in the High Court, weirdly, enemies of the people. Who do EU think you are, said the Sun. You can almost see that headline there. And the Tory graph carried profiles of the judges that made the decision, saying that they were somehow pro-EU. One of them, the Daily Hill, argued that they were pro-EU on the grounds they had previously worked with Tony Blair. I'm not sure how that makes you pro-EU. The photograph, by the way, is Gina Miller leaving the Middlesex Guildhall where the Supreme Court is held. So she was announcing. Look at that. Can you imagine the days when it was all right? Oh, it's literally the same photograph I've got down the bottom now. Oops, I completely forgot that. Never mind, it's fine. So there you go. What did this define? Well, it said the Supreme Court, they were the ones who decided when royal prerogative was correct. Now, government can still claim it, but if anyone challenges it, it is now the role of the Supreme Court to say whether or not that is correct, whether or not that is legal. That is an interesting case of power, and this kind of sets it. Secondly, it set the standard that the government must consult Parliament to change rights given by Parliament. Now, you could argue they always had to do that. All they did was clarify that position. That's what parliamentary sovereignty means. Remember, no parliament is bound by the decisions of a previous parliament, but each new parliament must make the decision as a parliament. A government does not represent Parliament. The executive does not represent Parliament. Parliament is a separate body. Now, if a government has enough of a majority, it almost doesn't matter. They can just force a vote through in the Parliament and it'll always be carried. It's why Boris Johnson and his government, after 2019's election, hasn't really had to worry about going back to Parliament. They can be reasonably confident and secure in getting anything passed because they hold an 80-seat majority. So there's that. Is it 80 or 60? I forget exactly. Thirdly, it said that the result of the 2016 referendum was not legally binding. Therefore, it was not enough for the government to claim that the people had spoken, that we had to leave the EU in the way that the government decreed. Rather, they said, no. You yourselves said that that referendum would not be legally binding. They did, by the way. And therefore, it's not legally binding. And that means, if Parliament changes its mind, then Parliament will have its way. Parliament didn't change its mind. Parliament went through 2 permutations after that in 2017 and 2019 and has ended up where it is. So Parliament ultimately did not change its mind. Though there was febrile moments in 2019 where they might have done. one of the reasons why the prorogation of Parliament became such a hot political issue. And the word prorogation entered in the modern lexicon. It's not something we really talk about. I have just realised I've gone over 30 minutes. So, tell you what, I'm going to continue this for a double lesson. Why the heck not? So, the fourth and final way in which the Supreme Court can affect the executive and Parliament is as follows. It can announce incompatibility with the Human Rights Act. So, a recap. They can't strike down acts of Parliament. They're not allowed. Parliament is sovereign. Parliament gets its way. Parliament does as it wishes. And the Supreme Court don't get to change that. They get to say that act can be used without used incorrectly, like secondary legislation and Chris Grayling, like local bodies infringing upon human rights. But they don't get to strike down the act of Parliament. Parliament is sovereign. Parliamentary sovereignty was upheld in 2017. After all, that was the whole thing that the Supreme Court hinged upon. Their decision hinged upon parliamentary sovereignty. However, what they can do is when any new act of Parliament is published, they are allowed to issue a formal statement of incompatibility. They can say whether a new law or a new act acts in tandem with the Human Rights Act as a provision within the Human Rights Act. Now, this carries no real weight beyond moral weight. When a court says this does not follow human rights, you can argue that creates a moral pressure on the government to make a change in their decision. But it doesn't have to change their decision. They can just go, yeah, and then carry on. They are, after all, sovereign. But it has to be an act of Parliament. It can't just be an act by the executive. So, here's an example, the Belmarsh case from 2004. We've talked about it before in Unit 1 when we were talking about this concept of how human rights and civil liberties are upheld by the courts. You might see a lot of crossover here. So we've talked about the Belmarsh case already. Forgive me for using the alphabet soup of the names of the Acts of Parliament here. So in 2004, the government under Tony Blair, was he behind this? Yes, he was. Used the anti-terrorism, crime and, what's it called? What's the S in there for? I've forgotten. Oh no, what's it called? Oh, poop. I'm going to have to look it up. Sorry, I'm looking it up as we speak. Anti-Terrorism, Crime and Security Act, my apologies, in 2001 to basically hold foreign terror suspects indefinitely, i.e. there was no requirement to limit their holding in cells because they were foreigners and they were not under English law. The law lords, remember the Supreme Court doesn't yet exist, found this discriminatory because it was only on foreigners. Had it been applied to UK nationals as well, then fine. But then, well, as it was, because there was clear discrimination, this broached the Human Rights Act. And they made that decision. And the government accepted that decision. Now, it's important. They didn't have to. Remember, they are sovereign. Ultimately, they could have challenged the law lords. They chose not to. And they chose to accept the decision. Well, that meant that So what they did was they passed a new law talking about control orders, in which all foreign terror suspects could be would have no right to privacy, essentially. All of those things could be viewed. And you remember Boris Johnson's quote about removing privacy being in the public good. And now he's Prime Minister, I'm just saying. So those control orders, because they're an act of Parliament, simply just bypassed the decision made by the then law lords, the highest court of appeal. This means the government can do what they want. This is fine. Yeah, everything is fine. And you might say, sir, that's an odd response. I know that meme. How is the room on fire? This seems perfectly logical. What are you saying? The government doesn't have tremendous powers? Surely not. Yeah, well, okay. Let me take you through a thing that hadn't happened in the textbook to prove what I'm talking about here and why I've used this particular meme. Home Secretary Priti Patel in the government conference, Conservative Party conference, October 2019, had a speech. You might recognise that image. I've played you some of that speech. And she said, those defending the broken system, she was referring to immigration here, people coming into the country and being allowed in to make their cases, to plead their case for asylum before being adjudged, and to do so from UK soil. Bear in mind, that's what she's talking about. These are the illegal immigrants that we often refer to, people that have not yet been judged upon as to whether or not they are rightfully seeking asylum. So we don't know, is the answer. We have no way of knowing because they've not been tried in court. That's not because they've broken a law or anything. It's whether or not they've been accepted as a genuine asylum seeker, as opposed to a not genuine asylum seeker, I guess, though there is no real stipulation for that in international law. Those defending the broken system, the traffickers, they're the people that transport people across borders and often do so unsafely and, in ways that are really quite nasty. The do-gooders, wait, what? The lefty lawyers, the Labour Party, wait, what? They are defending the indefensible. You say, sir, okay, that's fine. That's one of those statements that Priti Patel makes. There's no ings in there. Oh, no, defending the indefensible. Sorry, they're defending the indefensible. Defending the broken system. Because you can't do G's. And how is this even remotely relevant to your meme and the example you've used? This is a bit weird, isn't it? Okay. Let me contextualise. Following an attack by a right-wing extremist on a legal office who had supported cases brought by immigrants to gain asylum on the 4th of September 2020, so a year after these discussions were originally held, a year after she made her remarks, someone on the inside of that case said the following. With any case of domestic terrorism, you need to look at the reasons behind it. If you had a dubious politician abroad inciting hatred, and then a UK terror incident was traced back to what this politician had said, then you can only imagine the measures that would be taken. The man accused of the attack, and later convicted, said that he carried it out because he wanted to deal with the, and I quote, the do-gooders, the lefty lawyers. Oh. He was quoting Priti Patel. Now, it's also interesting that during 2020, she'd made those comments again, and, despite warnings, did so again during the Conservative Party conference. But I'm not going to quote her directly. I'm simply going to quote the Prime Minister. At the end of a statement, stopping the whole criminal justice system from being hamstrung by what the Home Secretary would doubtless, and rightly, call the lefty human rights lawyers and other do-gooders. The ability of government to simply sidestep this idea of human rights, to legislate around a decision by the Supreme Court of the United Kingdom, means that this sort of thing is fine. The Supreme Court can say, maybe don't do that, and they can ignore them. This is fine. Everything is fine. So, those are the four powers of the Supreme Court and how they interact with the executive and Parliament. They tend to uphold parliamentary decisions, they tend to uphold parliamentary sovereignty, but they tend to act to limit the powers of the executive with relation to Parliament, or at least that's what the examples seem to suggest, if you were to try and draw any kind of trend. Which brings me to the final debate. How influential is the Supreme Court? Now, this is supposed to be green, and I've got ticks going down the side. I'm so proud of myself. Basically, it is influential because it's the most senior court in the land, and it is the final court of appeal. Therefore, its decision tends to be final. It tends to mean something when they make decisions. They don't make many, but when they do, they're important. They're influential. Furthermore, Supreme Court justices are the most senior judges in the United Kingdom. Their interpretation of a law, their setting of precedent, is final. They can only be, I presume, overturned by another Supreme Court decision. Statements of incompatibility when it comes to the Human Rights Act bring moral pressure to bear, and governments are susceptible to moral pressure, or at least they were up until, I suppose, December 2019. Don't take my word for it, by the way. You can take the word for the government itself. They decide the location of sovereignty, and that will become increasingly important in this post-Brexit world where you're going to have competing claims of political sovereignty, for example, with devolved institutions. So does the Scottish Parliament have the right to call for an independence referendum. They certainly believe so. They certainly believe they've got the mandate to do so. So, who gets to decide whether or not that is held and whether or not it is legally binding? And they're going to judge when royal prerogative is legal, when it can be applied and when it can't. So, I've got a green box. It therefore follows I've got a red box saying they're not influential, and I've got crosses. So proud of myself. They can't strike down acts of Parliament. Parliament is sovereign. Parliament can simply legislate around anything they say. They cannot initiate cases. If they think something is wrong, they've got to wait for somebody to bring that case. They can decide whether or not it's their prerogative to hear the case, whether or not they need to go straight to the Supreme Court, whether or not it needs to be first done further down, but they can't make something happen. If no one cares, then it never happens. Even if they think there's a legal case to be prosecuted, even if they think there is a problem with a government decision, if no one calls for a judicial review, they don't get to decide that. If a new Act of Parliament comes out and no one says, is that in line with the Human Rights Act? Then they don't even get to say a statement of incompatibility. Governments can just ignore them, especially declarations of incompatibility. Can you imagine Priti Patel? Really? Caving to one of those? I can't. Can you imagine Boris Johnson caving to one of those? I can't, based on literally their words that I had up on here previously. So there's no legal requirement, no power that forces the executive to accept or act upon declarations of incompatibility. And although they can interpret laws, judges are still bound by the wording of that law. You can't just make up an interpretation. Oh, actually, I interpret the law to mean that this law that says that fox hunting is illegal, I interpret it to mean that everyone must eat pink blancmange. It's not in the law. Can't do it. So there's a limit on how far you can interpret a law. You are still bound by the wording of that law. If words have meanings, if words cannot be interpreted, then you can't do it. You're not a postmodernist. This isn't postmodernist literary interpretation. The meaning of a text is whatever you decide the meaning of the text to be. Absolutely not. Though you'll note that if you ever try and apply that to postmodernist arguments, postmodernists get really upset. Oh, I interpret your words to mean that actually you're a classicalist when it comes to this particular form of literature. And they go, no, that's not what I said. Then words have meaning. Sorry. I hear postmodernism and I get very upset. When are judging things being ultra vires, the government can just, go, yeah, okay, fine, and then legislate differently. So it's no longer ultra vires. They can just change it and it becomes law a different way. So striking things down, quashing things, yeah, sure. And then the government goes, yeah, we'll just push it through Parliament and it becomes an act of Parliament. You're going to stop us? So if a government's got a majority, do they care? No, they don't. And, all right, here's a test of how influential the Supreme Court is. Apart from even the names I've mentioned, go on, name them. Exactly. That's how influential they actually are. I assume it would be similar with cabinet government, but when I did that, I did point out that you could probably name some cabinet ministers. And even when I showed you just their images, you were able to do this, even if you couldn't name them all. With the Supreme Court, apart from the ones I've mentioned, could you name any of them? And that tells you how influential they really are. Now, this brings this particular video to almost 50 minutes in length. It's just gone 48 minutes. As a consequence, I think that's probably doable for a whole 2-hour lesson, or rather 2 hours worth of lesson time. Obviously, you've been using this video as a resource. That is, going backwards and forwards and checking things and using it to go back. If you've watched it all in one sitting, then thank you and well done you. But be aware that you can always go back to this. You don't have to watch the whole darn thing. I wouldn't even recommend it. Go through on 1.5 speed. Find the bit you're looking for. Slow it down. Bookmark it. Come back to it later. You get my meanings. So this should be enough to be getting on with for the 2 lessons that I've recorded this for. And hopefully it makes sense when we're talking about the Supreme Court. The next bit I'm going to look on into is the next bit in the textbook, which makes sense. The relationship between the executive and Parliament. We've already tackled this in a fair amount of detail. And a lot of the examples in the textbook, you will note I've already applied when we're talking about cabinet government. relationship within the executive, I suppose. So we can talk about this in a little bit more depth, sure, but it won't take as long. We should return to this, therefore, next week in the next series of videos. So we'll see how that goes. Because, of course, next week we start, and there will be at least 2 lessons where I have to do it remotely. So I'll make videos on that too. That won't take us as far as the EU, though I imagine there will be some kind of mix, I think, going forwards. But I'll talk to you about that when we're in the classroom. In which case, if you have been, thank you very much for watching. Have a lovely rest of your day. I hope that this has been useful, and I shall see you in the next video. Bye-bye now.